Information contained on the following program off the record does not constitute specific legal advice for any real case. Off the record is presented for entertainment and general information only. Listeners are advised to consult an attorney for their specific legal questions and guidance, and not to rely solely on information presented on this or any other law program.
It's time to go off the record. Need insight on how the law works? You found the right place. Legal questions, you found answers. Thanks for joining us. Off the record. Here's attorney Julie Jordan de Palma.
Happy New Year.
Happy New Year all.
Nice to be here. How are you? How's the new year treating you?
So far, pretty well. Of course, it's only January 2nd as we record this show, but...
Have you picked resolutions?
No.
None?
No.
Because they just get broken?
Well, yeah, let's put it this way. It's not a priority.
Fair enough.
Maybe it should be, but it just doesn't. Because, I mean, the best predictor of the future is the past, and how do resolutions go for most people?
Not well.
Right.
Not well. I read an article this morning that said one of the ways that we have to be able to keep our resolutions is to learn more about showing gratitude for what we have. That will provide us self-control.
An attitude of gratitude. I like that.
Do you think it works?
I think it does, actually.
Fair enough.
Yeah. I try to espouse that. Here I go with the Pollyanna Act. But I try to espouse it every day. I really do.
3 things you're grateful for. They say that if you take 21 days and every day think of 3 things that you're grateful for, it can change your entire outlook for the whole year.
Boy, I'm telling you, the advice you get on this show is not just legal, ladies and gentlemen.
It is not. So I have something I'm grateful for. I brought it with me today.
You brought it with you?
I brought my...
Well, let's meet it.
Him with me because I'm grateful, not it. Him. My one of the things I am grateful for. So today I decided I was going to bring a guest with me. Mm-hmm. And the guest that I chose to bring was my other half, my partner in life, but who also happens to be a very excellent attorney. Jeff de Palma is in the studio with us.
Happy New Year to everyone. I am grateful for being invited to this show and have an opportunity to see what goes down here in Radio Central.
There you go. And an excellent answer, really, so that, dinner and things are nice at home. I don't think he has an option other than to say he's grateful to be here.
I think you two should have dinner down at Fratelli's, down at the corner on your way home.
How does that sound?
It sounds great.
Are you treating?
You like Italian?
Cook for the children, but...
That is a problem.
Sure. Tell them to throw some microwave mac and cheese in and watch their favorite show.
There you go.
They'd probably like that better.
They probably would. Sad but true. So today, Jeff de Palma is here with us, and he's here because I decided that in light of the weather that we have been having, with the snow, with the ice, what do people tend to ask about? Slip and fall cases this time of year. 'Tis the season. And we joked on the way over here that in light of the recent weather we've had, about 3 years from now, desks will become full of potential cases that need to be sued out. And in light of recent shows where we talked about people can have differing viewpoints, but get along well and enjoy the differing viewpoints. I am the plaintiff's attorney in the household, and Jeff is the defense attorney in the household.
That's
so we're going to have
perfect.
all perspectives.
I like that very much.
But interestingly enough, the reason Jeff is here today is because in light of a lot of different defense work that he does, he has, by chance, helped out quite a number of snowplow contractors and other property owners and defends them when people slip and fall on their property. So today we're going to talk a little bit about slip and falls and liability and how to defend those folks and small businesses who may be worried about that this time of year. And some of those small business owners are snowplow contractors, and what they should be looking out for and what plaintiffs should be thinking about and plaintiffs' attorneys. But most importantly, we're going to talk a little bit about slipping and sliding today.
Slipping and sliding is a big part of the practice here in the Northeast and certainly in Western New York. As you mentioned, a lot of people will unfortunately suffer slip and falls throughout the year, sometimes because they weren't paying attention, but oftentimes because the conditions are such that there's just no avoiding it. Slip and fall is a premises liability. What that means is that the owner of a premises, regardless of whether or not they are on site or not, has what's called a non-delegable duty to keep their property reasonably free from hazardous conditions, one of those being the accumulation of snow and ice. And what we see is that frequently, a lot of times in commercial spaces, such as shopping malls and grocery stores and small radio stations.
No, not that one. I was just waiting for that shoe to drop.
Never. Always well salted.
That people will slip and fall, and sometimes the injuries can be very serious. It depends a lot on how you fall, which is one of the key components that people forget about and are frequently asked when they do bring a lawsuit is, how'd you fall? And most of the time people will tell you they don't know. They don't know how they fell. They don't know whether their feet slipped out from them, whether they tripped, whether their foot got caught in something. But that is certainly a key element to any type of slip and fall case.
So before we go any further, we didn't do complete and full introductions, and I think it's probably important that we do that.
Let's do that.
Because one of the reasons that Jeff is here today is because he has a little-known nickname, which is TED Talk Jeff.
TED Talk Jeff.
TED Talk Jeff.
I was afraid you were going to say something like the Hammer, and I'm so glad that that's not the case.
No. TED Talk Jeff. Because a lot of times legal or even non-legal, most times non-legal, you can put a question to Jeff and something akin to a TED Talk will come out. So he is here to give his TED Talk on snow plowing. But before you get into that, why don't you tell a little bit about where you work, what you do, why people should generally listen to the information you're going to give us today.
Well, I am a partner at the law firm of Osborne, Reed & Burke in Rochester, right in downtown. We primarily do insurance defense work as a firm. We also do a lot of defense of the medical providers, the insurance providers, both Unity Health and Strong, University of Rochester Health, in regard to malpractice cases. But I primarily focus my practice on the defense of products liability cases and insurance work, which encompasses in large part premises liability, which, as you mentioned, is frequently a slip and fall situation. I represent both property owners in some cases, and frequently I will also represent snowplow contractors who get brought into the cases as the result of their contract with the owner to keep the property clear of snow and ice.
So explain the dynamics of how that happens, how the snowplow operator gets drawn into this. Somebody slips and falls on business property, let's say, which has been cleared by, let's say, one of your clients.
Well, generally speaking, and this is a little counterintuitive, but a plaintiff cannot sue the snowplow contractor for their injuries because they didn't have the contract with the snowplow provider.
A thing called privity.
Privity, correct. But the property owner can sue the snowplow contractor if it is ultimately shown that the snowplow contractor did not comply with the terms of the contract. So, for instance, a lot of contracts have rules called the 2-inch rule, which is that the contractor doesn't come out until there's 2 inches of accumulation. So if you have a situation where there's more than 2 inches of accumulation and the snowplow contractor didn't come out and clear during the period of time that they were allotted per the contract, and a person slips and falls, the plaintiff sues the property owner, but the property owner then sues the snowplow contractor saying, look, although I may be held liable for this condition because I have the duty, you owed me a duty per contract and you violated that. And therefore I receive what is commonly referred to in the legal circles as indemnification for all of my damages as the property owner. But the plaintiff themselves, only in the rarest of occasions, can sue this snowplow contractor successfully directly.
So how do I know that? Plaintiff comes into my office and says, Julie, I fell yesterday in this parking lot. Well, I'm not going to know if there was a snowplow contractor. So as a plaintiff's attorney, generally I'm going to sue the property owner
and quite
as
frankly,
a first step.
Quite frankly, that's all you care about. the property owner will bring in the snowplow contractor to seek the indemnification. You want to get the person who can't get away from the liability. And as we said before, the property owner has a non-delegable duty. So regardless if they try to get somebody else to take care of it, they are ultimately responsible.
So tell our listeners, TED Talk Jeff, what indemnification is and what it means.
Okay, well, indemnification is a situation where one person is held liable for the fault of another. That is either by statutory means or common law. In this case, it would be a common law type indemnification. Could be contractual indemnification depending on how the contract reads. But what that means is that ultimately, if the plaintiff is successful against the property owner can receive back all of the damages that they paid out, plus, if it's common law indemnification, any attorney's fees or costs that they had to pay to defend the case.
So here's a flip side of it. I am a small business owner. I have a property, and I want to go out and make sure that I have a good contract with my snowplow contractor. What, if anything, do I want to make sure that it includes?
Well, as a property owner, particularly if you are a commercial site, you can usually dictate some of the terms to the snowplow contractor because there is more supply of snowplow contractors than there is demand for commercial spaces. The key thing that you want to have, this is what's called an additional insured portion of the contract. That is that you as the property owner get named as an additional insured on the snowplow contractor's insurance policy for up to $1 million. And in that sense, you don't have to worry about ever suing the snowplow contractor because the snowplow contractor's insurance is going to cover you and any type of indemnification up to that first $1 million.
I have a question in the back row here. What about what I will call boilerplate snow removal contracts? And I think I'm going to number myself among that, in that phenomenon where you just get, sometime in October, the boilerplate pre-printed snow plow contract for the season. It's will come. Sometimes you specify you mentioned the 2-inch rule. You can specify in some of the contracts 3 or 4 inches if you want to, what the price is going to be, and so on and so forth. But you don't read all the mumbo jumbo that's in there. It's like all the insurance policies that you can't possibly understand even if you bother to read them. What effect does that have on your liability as a property owner?
Well, generally speaking, you're going to have some significant problems suing your snowplow contractor unless you can show that the snowplow contractor created a dangerous condition. And that doesn't mean by failing to come out, because as it's been defined in the law, creating a dangerous condition or launching an instrument of harm is making the situation worse than had you done nothing at all. So in the absence of being able to show that the subcontractor, vendor, snowplow person made it worse than had they not come out at all, without some sort of contractual language to save you as the property owner, you're going to be in an unlikely position to succeed in lawsuit against the snowplow contractor.
Very good. Thank you.
So let's back up for just a second on premises liability cases. So let's talk about what they are, how liability gets established in the first place. So the first piece is duty, right? You and I sat through our torts classes once upon a time to learn the basics of duty, that the property owner then breached that duty in some way, which therefore caused someone damages, whether that's personal injuries, economic damages, etc. So as a property owner, how do I meet my duty to keep my property clear and safe of hazards? What is a reasonable expectation of a small business owner in upstate New York, do you think?
Well, I mean, premises liability is a well-litigated issue, and as a result of that, it has its own elements that have been pretty much laid out in common law, case law, and specifically the issue that is in premises liability that frequently is not in a case such as an automobile accident is the issue of notice. And there are two types of notice. There's what's called actual notice. That's what everybody thinks of. Your customer comes in and tells you your parking lot is icy, particularly by the front entranceway, and then 20 minutes later somebody slips and falls on that ice. You had actual notice of the icy condition. More commonly, what we hear about in the cases that I handle is something called constructive notice. And that's a situation where there is some sort of proof that the condition lasted or was present for a period of time sufficient to become noticed with reasonable inspection and a sufficient time to remediate the problem, that is, remove the snow or mitigate the icy condition. And then the last part of that issue is situations where, again, you can show that the property owner created the hazardous condition. And as I said before, that is not just merely letting snow and ice remain on your property, but instead is a situation involving making it worse than had you done nothing at all. But one of the issues that comes up with property owners is a situation where it's not just snow and ice, but it's a defect in the property that creates the snow and ice condition. And we see this a lot in circumstances with gutters and bad roofs. And what that creates is a persistent situation where whenever it's rainy and cold, you get unusual buildup of snow and ice or ice in the area where the gutter is defective. So
that's the situation where I'm minding my own business and I go to a restaurant with a family member and the gutter over the door is always leaking, and everyone thought that drip wasn't a big deal. And turns out as the weather gets worse, we have a puddle by the front door which freezes over and someone falls and slips on the sidewalk.
Correct.
So when we get back, we're going to continue to talk a little bit about defects in property. We'll start there. Various defects and how it can create liability. We have our guest, Jeff DePalma, with us today. Nice to have you.
Nice to be here.
Talk to you after the break.
2 DePalmas for the price of none here on Off the Record on WYSL. We're giving them actual notice of going to a break, and we'll be back after that.
Myself, wait until I know you better. I am trying not to tell you.
The senior citizen in your life deserves to be treated like family in every way, and you deserve the peace of mind that comes from knowing your older family member is getting personalized care, even though they're not yet ready for a nursing home. Consider Alpine Manor, founded in 1971 by owner Tim Kinsella, and just 20 minutes from Rochester in Lima, Livingston County. At Alpine Manor, they're experienced in caring for seniors showing symptoms of confusion, forgetfulness, or memory loss. There are supervised activities and medications, full laundry and housekeeping services, all provided in immaculate surroundings. If you're headed to Florida or other warmer regions, you can go secure in the knowledge that your loved one is well cared for back at home. You could qualify for $1,600 per month VA benefits or $1,100 benefits for a surviving spouse. Alpine Manor, New York State Health Department licensed. Call 346-5880. That's 346-5880 for a no-obligation tour or information, or visit alpinemanor.com.
Celebrating our 45th year.
At University Eye Specialists, I see many patients who suffer from dry, irritated, or itchy eyes. Sometimes these symptoms are often due to severe dry eye. Over-the-counter eye drops often help, but sometimes dry eye may require treatment with prescription medication. Dry eye is a very treatable medical condition that should be taken very seriously. The health of your eyes is very important to us. Please feel free to call any one of our local offices for an appointment.
In America, we are living longer, healthier lives. The longer we live, the more likely we are to develop eye conditions such as glaucoma, macular degeneration, and diabetic eye disease. If you are over the age of 40, it's important to have a thorough eye examination in order to identify vision-threatening conditions at an early stage. At University Eye, we have the technology and experience to screen for and to treat glaucoma, macular degeneration, and diabetic retinopathy. At University Eye, your vision is our mission.
Phone 1-800-724-0938.
Suffering a serious injury because of medical malpractice, nursing home neglect, dangerous conditions on property, or a car accident can make your life feel like it stands still. How will you provide for your family and overcome this loss? I'm Julie Jordan DePalma. I'm a trial attorney, but I'm also the daughter of someone who suffered a disabling injury. When you need someone to provide compassionate guidance to your family, but be a fearless advocate to your opponent, call the law offices of Jordan DePalma at 585-673 613-3053.
Nothing impacts your general health and well-being like a healthy smile. Your days of living with broken or missing teeth or struggling through a never-ending cycle of dental repairs are over. State-of-the-art dental implants look like your own teeth but are so much better and restore your healthy appearance and full function. Register for the next free informational seminar about dental implants at livoniasmiles.com or call 346-3028. Lakeview Dental, for the smile you've been dreaming of.
You're listening to Off the Record with Julie Jordan DePalma on WYSL 92.1 FM and 1040 AM.
Notice our bump music theme. It's all about falling. This is Tom Petty's Free Falling on Off the Record.
We hope no one has free-falled in a parking lot or sidewalk before our show.
Try to avoid that.
We want to try to avoid that. We want to help the small business owners know how to protect themselves, what defenses they have, and when, if you are a plaintiff who has fallen, you do have a good claim that you should bring forward. So in this segment, we're going to talk a little bit about defects on property, and also Jeff keeps bringing up this concept of launching an instrumentality of harm. So we'll talk a little bit about that too, but before the break, we had started to talk about defects on conditions and some examples of that, and one of them we said was the leaky gutter that's there. It's over the roof of the entranceway. Everyone kind of disregards it because it looks small. It looks like it's not a big deal, and here we are in upstate New York, and that leak becomes the puddle on the ground, which becomes the patch of ice, which is the same color as the sidewalk. Someone falls, and all of a sudden, our trip to the restaurant is not nearly as fun as we had hoped.
No, and the issue that is developed from that, it goes directly to notice. So typically, like I said before, you either have to actually know about the dangerous condition or there has to be proof that it was there for a sufficient period of time. But when you have a persistent defect like a leaky gutter, a depression in your parking lot, clogged drainage systems, that takes the notice issue away insofar as if you know that that condition exists on your property and you know what triggers that condition, snow, thawing conditions and refreeze, then you are considered to be on notice. So when you're a small property owner, you can't just disregard potholes in your parking lot saying, well, that's just something for cars, because as we know, potholes are good places for water to pool, and that's a situation that can strongly develop into a slip and fall, and you will be on notice because you know that that pothole exists, and you know that when there's snow or ice conditions, that pothole presents a danger above and beyond normal parking lot conditions.
So I think one of the things that people have heard or learned over time as this case law develops, people have picked up on, well, it's just a trivial defect. It's not a big deal. It's not big enough. Talk to us a little bit about the size and nature of a defect as a property owner that you want to pay attention to, that isn't necessarily going to be seen as trivial. It's the kind of condition that's going to create the concept that you had noticed, that you should have known, you should have done something about it to properly inspect, maintain, or repair.
Well, trivial defects usually don't result from snow and ice conditions. They result from, particularly in upstate New York, what I like to call is frost heave, is that you have a situation with particularly a sidewalk. And what happens is that during the spring, when you have the frost and it melts back down, it doesn't settle evenly, and then you have a lip between your sidewalk slabs as you go forward, and people trip over those. That is frequently where the argument of whether or not it is a what they call a de minimis defect in property, and unfortunately that is in the eye of the beholder. So
I can't take my measuring tape out and call you up for a chart and you tell me whether it's de minimis or not?
No, because it's basically a question of fact for the jury, and those 6 people come from all different points of life. I've had cases where a 2-inch defect in the sidewalk has been considered sufficient, and then I've had situations where there's almost a 6-inch defect in the sidewalk where the jury said that wasn't something that was sufficient to be deemed a hazardous condition or something that the owner would reasonably realize to be defective. And that's another important fact that often gets overlooked by lawyers, and that is it's not just that you have noticed that the condition exists, but that you have a reasonable expectation that that condition is dangerous. And one of my favorite cases that I just got through is what has been infamously called the Garland case, where we had a situation where a plaintiff had gone into the store to buy Christmas decorations, and she found some garland, and it was the middle of the rack, and she went to pull it out. And as she pulled it out, she realized that it was entangled with garland that was above it. And as she pulled on it, the garland started to fall toward her, and it startled her, and she jumped out of the way. She lost her footing, she fell, and she broke her wrist pretty severely. What the court held in that matter was they said, although that may be a hazardous condition, we're not going to debate that or not. It's not one that a store owner could reasonably perceive, that the overstocking of garland or the entanglement of this garland was something that would result in a person falling down. So that comes into play with situations like the sidewalk. Would a reasonable person looking at the sidewalk think that that was a dangerous condition? Not just that it existed, because it obviously exists, but is it something that is dangerous, reasonably foreseeable to be dangerous? And that is almost a question completely in the jury's purview.
So what happens to my poor plaintiff who slips in the puddle on the leaky gutter and falls and has a significant injury?
Well,
should a property owner perceive that to be a potentially dangerous situation?
Certainly, if it's creating icy conditions and they knew about that beforehand, that is almost always going to be notice of that dangerous condition. Then the question becomes, did the property owner take reasonable steps to mitigate that dangerous condition? Did they put salt down? Were they inspecting the property on a regular basis to see whether or not that type of condition was developing in the specific instance when the plaintiff fell down?
So what about a property owner who has limited staff? What do they have to be worried about? Because when you say to me reasonable inspections, the flip for me, if I'm a small property owner, is what are reasonable inspections when we live in upstate New York? Let's say I run a restaurant. Let's say I run a small business and I'm open 9 to 8 p.m. and I have people in all times of the day. How many times do I have to be outside taking an eye on my sidewalk or my parking lot to make sure that if these things are creeping up, I'm dealing with it or my people are dealing with it?
Well, again, frequently this becomes a question for the jury, but as a rule of thumb in New York, at least insofar as it deals with a defense called storm in progress, in the Western District of New York, which is where we live, the rule is that you have 2 hours from the cessation of a storm to find any defects in your property and caused by the storm and mitigate those.
What does cessation of a storm mean?
Well, a storm is very broadly defined in New York, but basically it is the end of any precipitation event, any type of scenario where ice can be formulated. But there's an exception.
Rain, sleet, snow, or hail, just like the mail. The mail is going to get through it, but you need to be out in your parking lot?
That is correct. It could also be a drastic temperature inversion, such that you may have a situation where there was melting snow and then there was a rapid decrease in temperature, which we experience a lot here, that creates an icy condition. Basically, that can also be considered a storm, depending on how well defined it is, and you have 2 hours. Utilizing that 2-hour rule, reasonable inspections have generally been held that if you are inspecting your property during periods of time when ice may be formed, and you're doing that check every 2 hours, most courts have held that as a matter of law, that is a reasonable period of inspection.
So policies and procedures that have checklists where you've got a certain staff member who either is checking your sidewalk or checking your parking lot every 2 hours, generally you're going to be in good shape if you follow that.
Certainly. And again, you have to look at the type of business it is, and you have to look at whether or not there's going to be traffic there. If your business is closed, there's no reasonable requirement that you be out looking at the parking lot.
Now, the important piece is you have to do it.
You do have to do it.
Because plaintiffs' attorneys like me will come and find you. If you have a policy and procedure in place that you're checking things every 2 hours and I get your sign-up sheet and it hasn't happened.
That is true. You definitely need that checklist, and you need to keep it up to date.
All right. When we come back, we're going to talk more about slipping and falling in upstate New York.
Since I met you, I've begun to feel so strange.
Insulation. It's a smart idea since it keeps wind from whistling right through your windows, summer heat from your attic from baking you alive, or cold floors in the winter from turning your toes blue. And maybe you know that Icynene foam insulation is the best smart idea since it gets into spaces other insulations can't touch. Icynene fills small openings and gaps in your walls and around windows and doors that add up to big heating and cooling savings, as much as 50%. But the experts at Burt's Lumber and Building Supplies in Perry want to remind you, no matter how great the material, only proper installation assures you that your Icynene insulation will give you the ultimate in comfort and energy savings. You can always identify a Burt's insulation customer, from their comfortable smile to the extra money they enjoy every day from utility savings. Don't trust your insulation project to any here today, gone tomorrow guy with a pickup truck and a sprayer. Call Burt's Lumber and Building Supply, Washington Boulevard in Perry, 237-6128. Do it today and start saving.
Suffering a serious injury because of medical malpractice, nursing home neglect, dangerous conditions on property, or a car accident can make your life feel like it stands still. How will you provide for your family and overcome this loss? I'm Julie Jordan DePalma. I'm a trial attorney, but I'm also the daughter of someone who suffered a disabling injury. When you need someone to provide compassionate guidance to your family, but be a fearless advocate to your opponent, call the law offices of Jordan DePalma at 585-673-3053.
Eyes in Rochester is a full-service ophthalmology office, and we specialize in general ophthalmology, taking care of people from childhood to adult and seniors. We do general eye exams. We specialize in cataract surgery, corneal surgery, and disease, as well as LASIK surgery. We also have a full-service optical shop and contact lens fitting service.
Visit Eyes on Rochester at 1157 Fairport Road.
At Family Furniture in Perry, get everyday savings without big chain store hassles. Find out why Family Furniture is the shopping destination for thousands all over the region. Need a new mattress? Come in and try their all-new Echo Gel-infused memory foam, or the solid latex styles for the finest support and comfort available today. Instead of the big Rochester showrooms, shop Family Furniture in downtown Perry, serving you for over 65 years. Open Thursday and Friday nights till 7, Saturdays till 4.
At Finger Lakes Gaming and Racetrack, making you feel like a top dog is what we do. Try your luck on our 1,500 video gaming machines and enjoy Finger Lakes Gaming's award-winning Vineyard Buffet. Or watch your favorite team on the big screen at Remedy Bar and Lounge. Hey, when's the last time you felt like a top dog? Go fetch that feeling at Finger Lakes Gaming and Racetrack, Route 96 in Farmington. And check us out at fingerlakesgaming.com. Must be 18 to play video gaming machines.
We're keeping it legal with Julie Jordan DePalma on WYSL 92.1 FM and News Power 1040 AM.
Okay, real quick, I want to jump in here with another one of my fabled questions. We've been talking about duty with regard to the business owner, the duty that devolves upon the plow operator. What duty does the business invitee have in encountering possible hazards on premises?
Well, it's what any reasonable person would have. Is the rule is if you are aware of a dangerous condition, then you have to take reasonable steps to avoid it. Frequently what we see with people who slip and fall and have meritorious claims is either the dangerous condition is such that it couldn't be avoided. It's so icy, the parking lot presents itself in such a situation that there's no way to move across it without getting exposed to the icy condition. Or what we run into is a situation where the person is distracted either because they're looking for traffic, or they're trying to look at a child and make sure that the child is safe. And while they're walking and they're looking at something else, they encounter this icy condition that they didn't perceive, and that's when they slip and fall.
I'm thinking running along with a cell phone.
Running along with a cell phone. How about those that are more concerned about their fashion than their footwear? So another, here's a simple piece. Ladies in particular, put the pretty shoes in the bag and put some boots on. One of the first questions that my other half over here, once sitting on a defense table, is going to want to know is, what kind of footwear were you wearing? What were you doing? Did you have a purse in your hand? Were you carrying things? Were you looking at your phone? Were you with someone? Were you having a conversation? So the basics of just being aware of your surroundings, attempting to be careful, being thoughtful about how you're walking, how you're moving about. Those are all the basics. Then once you've established that you've really done those things, you've taken reasonable care just as a person coming in and out, then that next step is what's going on the property.
And even if you're unreasonable, let's say you're talking on your phone or you're wearing shoes inappropriate for the weather condition, it's not going to necessarily bar your suit. What it does is it may lower how much fault is attributed to the property owner versus how much is attributed to the plaintiff, because it's not an all or nothing situation.
So this gets into a calculus of where you actually can see percentages, where you say the plaintiff is 20% at fault, and any recovery would be reduced by that amount.
Sure.
Correct.
And that's one of the questions, once you get to a jury, let's say you get to trial, one of the questions the jury is going to be answering is doing just that. Here's a blank with a percentage. How much percentage of fault is attributable to the plaintiff, the person who was hurt? How much of it is attributable to the property owner in a case where that's who's brought in? So people are going to get to say. And guess what happens in the typical slip and fall? What do you think the percentage is?
75-25?
You would like that as a property owner, but a lot of times people default to 50-50, right? They default to the 50-50. The person should have been looking. They should have been aware. They should have seen something.
Now, these are the jurors. This is not the judgment.
Your typical juror in a slip and fall case will kind of split the baby 50-50. The person should have been looking and the property owner should have been more aware. Now, I think that's different in your ice in a parking lot in upstate New York. I think that weighs more in favor of a property owner for sure.
To win as a plaintiff on a slip and fall in ice in upstate New York is very difficult because we are tough up here in western New York. We're used to snow and ice. We expect our fellow upstate New Yorkers to take that reasonable care and know what to do when they're confronted in a parking lot that has snow on it.
Yeah, absolutely. Your typical 50-50 is I'm walking about in decent weather and I'm in the grocery store, I'm outside on a sidewalk, I'm walking in somewhere, I'm on someone's property and I fall. Snow and ice in upstate New York, much less. And you used a phrase that sends chills down plaintiff attorney's spine, which is storm in progress. So define storm in progress for us. Tell us what that means.
The storm in progress is a defense. It basically deals with duty. And what it says is that a property owner has a reasonable period of time after the end of a storm to clear snow and ice conditions. And in the 4th Department, where we are, that's 2 hours. Some of the other departments have more time. I guess they don't expect people to be as good at snow removal, but our department says 2 hours. And what that is when the precipitation or ice creating event ends, you have 2 hours to find any snow and ice conditions and remove
Clear them up, remove it. So in other words, if the sleet is coming down, if the snow is coming down, you don't have to actively send your employees out into the storm to attempt to clear something as it's just being created right on top of them as they're trying to clear it out.
And quite frankly, because of the way case law is set up, you shouldn't send your people out during the course of a storm.
I should not be a good Samaritan because why?
Because if you go out during the course of the storm, then you have assumed the duty to clear snow and ice, and it becomes very difficult to tell whether or not the snow or ice that the plaintiff may have fallen on after the snowstorm was snow and ice that was created after you did your attempts at snow removal or before that. And that will put you on notice of your dangerous condition.
So how about this issue, which is cars are in and out of parking lots all the time. And I've cleared the snow. I've got a nice even patch, but it's wet either because of the snow or the rain, and the cars are in and out. Their tires are hot, and guess what they're doing? They are creating more ice. So what am I supposed to do in a parking lot where people are in and out all the time? You think of a huge place like Eastview Mall. The place was packed yesterday. How can a property owner like that possibly alleviate the ice that's going to be created as those cars are in and out all day long?
Well, you're never going to be able to completely alleviate it, but this goes back to what we talked about before, and that is having a procedure that can be perceived as reasonable. That is, you are having people regularly and routinely driving through the parking lot looking for icy conditions, and I know Eastview Mall does this, is that they just have scheduled periodic salt distribution regardless of the conditions when the temperature is below freezing, such that every 2 hours a segment of the parking lot gets salted. Now, that's pretty unreasonable for most small business owners. So the recommendation that we do when we talk to them about risk assessment is putting into place a situation where you are doing a checklist and you are looking at your parking lot every couple of hours to make sure that that condition isn't being created.
So earlier you talked to us about launching an instrumentality of harm. Give me an example where a property owner can be accused of launching that instrumentality.
Frequently in the snow and ice situation where we see it is a situation where when plowing is done, it is plowed over the top of the drain. And what happens is you have a thawing event, that is the temperature gets above freezing, this big pile of snow that you've created in your parking lot starts to melt, but none of the water can get off of the parking lot because you have such an amount of snow covering the drain that it starts to spread across the parking lot, and therefore it is creating an icy condition that otherwise wouldn't have existed had you not plowed the snow the way that you did.
How about this one? I plow the snow and I make the pile so high that people can't see past the pile to know if a car is coming, and there is a car accident in the parking lot.
That is a more unique scenario with snow removal. To be frank, I haven't seen it in that situation. I have seen it in another situation involving a construction site where they put dirt, spoil pile, and then it snowed over the top of that. But that just goes down to notice. Did you know that that pile was there? And more importantly, as the property owner, did you know that that pile prevented people from being able to see oncoming traffic? And quite frankly, if the pile's high enough, and I've certainly seen these in
We've seen
commercial
those
lots.
piles until Mother's Day.
Those
Some
are
of these
dangerous.
lots, right?
Those are dangerous, and you are taking a chance. But what you try to do is put those piles out of the line of traffic as best you can.
How about this one? How about I am the individual who has decided to throw a plow on my truck and make some extra money this season. What do I want to do to protect myself as that small business owner?
Well, you want to
As
make
I'm plowing, as I'm making contracts, as I am doing my work. What about the individual snowplow contractor?
You want to make sure that you are not agreeing to take over the comprehensive maintenance of the parking lot. So you want to...
So what does that mean? What language do I want to make sure I never see in a contract I sign with one of these plazas?
Well, what you want to see is some sort of reservation of responsibility to the owner. That is, and frequently we see it with ice remediation, which is, I don't salt unless you tell me to salt. Me being snowplow contractor, I'll provide salting as part of the service, but you have to tell me that you want it. And if you want it, then this is what it's going to be charged at. And I've really found that that's probably the best way to protect yourself in regard to ice situations, because it is almost indisputable that the property owner has retained responsibility for determining when salt is going down.
And if you don't get the call, you're fine.
You don't get the call, you're fine. Or if you get the call and you don't have a reasonable period of time to get out there to put it down, you're fine.
What's a reasonable period of time? Property owner calls me. How much time do I have to put my boots on, grab a slice of pizza, get the coffee in my coffee mug, and get out there?
Again, that's going to be up for a jury. The situation is generally, how far do you have to travel? How many trucks do you have available? What other contracts you may have? How bad is the condition? Do you have the salt on site? Do you have to go off site to pick up the salt to put in your truck? Do you need to call in additional personnel to get that done? Those are all factors that are going to weigh into whether or not you responded in a reasonable time.
Responded. So let's shift over for a moment as the plaintiff's attorney in the room to what should plaintiffs do? You've slipped, you've fallen in a parking lot. Now it's time to start to think about, do I have a claim or not? What are the things I should be trying to memorialize? What are the things I should be doing?
First of all, you have to be injured.
you do have to be injured.
I mean, I'm not
No
talking about
question
like a
about
bruise,
it.
right? I mean,
Right.
is there a threshold, injury threshold, a broken bone or a sprain? Or
No, it's not like a car accident case, for example, in New York, where you need to have a serious injury to be able to bring your claim. You can certainly have any injury, bumps and bruises, and go to an attorney to ask about that claim. Now, I think it's fair to say that few attorneys are going to take that on unless you have a more significant injury. And you can do some other things, and Jeff alluded to it earlier today, which is you have to actually be able to identify the condition which caused you to fall. And a lot of times this is what hangs people up, and this is a turning point in a lot of cases for, is an attorney going to take the case or not? If you have no idea what you fell on, if you can't identify it as ice, water, some other substance, or you simply tripped, then you can't identify the condition, right? And in order to show that somebody breached a duty, you've got to be able to explain what the defective condition was. And if you have no idea, you've fallen and you don't know why, guess what? That's not a good claim. But let's say you've identified it. You've seen the frosty colored ice. You tried to avoid it and couldn't. Now that's the better claim, and now you're starting to look at these logs of inspection and talking to the property owner. So when we come back, we're going to wrap it up with what you can do if you're a plaintiff and you've been injured, and what steps you should take to memorialize what's happened after the break.
It's Off the Record with Julie Jordan DePalma and Jeff Jordan as well. Jeff DePalma, I should say. Excuse me. Yeah, details. We'll be back on WYSL.
Trappist monks worldwide have dedicated their lives to seeking union with God, supporting themselves through the work of their hands for hundreds of years. In 1953, centuries-old traditions came home with the building of the Abbey of the Genesee, where monk's bread has been baked for almost 65 years. White, raisin, cinnamon, sunflower with rolled oats, whole grain, delicious Genesee rye, and more. Ask for monk's bread at your local market or visit the bakery store at the Abbey in Peffard. Your purchase of monk's bread supports the monk's simple life of prayer, spiritual reading, and work. Now, the monk's bread traditions of quality and good taste can help your school, church, service club, or other group raise money with a monk's bread fundraising program. Folks can't resist the great taste and fresh quality of Monk's products. Get details at monksbread.com and click on the fundraising page. Let Monk's Bread help with your group's next fundraiser.
If you're looking to market and grow your business, make new business connections, and give back to the community in a meaningful way, consider joining the Greece Regional Chamber of Commerce. We're the largest suburban chamber in Monroe County, and we offer networking, education, marketing, insurance, and advocacy. You do not need to live or work in Greece to join. Our members come from throughout the region. In short, we're better together, and together, we're moving business forward. Visit greecechamber.org or call 585-227-7272 to join today.
Suffering a serious injury because of medical malpractice, nursing home neglect, dangerous conditions on property, or a car accident can make your life feel like it stands still. How will you provide for your family and overcome this loss? I'm Julie Jordan DePalma. I'm a trial attorney, but I'm also the daughter of someone who suffered a disabling injury. When you need someone to provide compassionate guidance to your family, but be a fearless advocate to your opponent, call the law offices of Jordan DePalma at 585-673-3053.
For breaking news.
Right now, a police investigation is underway in this city.
Police are still working to determine exactly what happened here tonight.
For weather where you live.
A nice chance for some sunshine. Travel overnight into tomorrow will be challenging.
For investigative reports.
We're about to show you the most unique crime prevention story we've ever done.
Who's going to know more about breaking into homes than the people who actually did it?
Watch News 10 NBC. It's where WYSL listeners get their news. Julie Jordan DePalma's Off the Record on WYSL 92.1 FM and 1040 AM. Online at WYSL1040.com.
So we've had a lot of time in my radio show, I notice, where my husband is talking a lot about defense things. So I've given it over to the defense side for, it looks like 3/4 of the show now. Is that about right? I think it's my turn.
You've gotten a few licks in there.
I think it's plaintiff's turn. So we promised before the break.
Plaintiffs go first. I don't understand how this happened.
Well, and we also go last. We also get the last word in front of the jury. So I guess this is my last word moment. So if you are the plaintiff who has been injured, we'll talk a little bit about what should you do now. So if you are in a position where your injuries don't prevent you from doing it, whether you or a family member can try to get some pictures, because guess what happens in upstate New York when we have icy conditions? It can be completely different. 2 hours from now, 4 hours from now, the next day, guess what happens? We can't prove what you slipped on or what it looked like or what you saw or didn't see. If you can get you or a family member, go in and report what happened. How many times do people come and say, I was injured, this is what happens, and the first question out of my mouth is, did you tell someone? Did you report it? Did someone do an incident report? And I never went in. If you slip and fall in a parking lot and you never go in, Jeff, what do you do when your client comes to you and they say, I have no idea this person fell, and now it's 3 years later, the statute of limitations is about to expire, and they say they fell. Now what?
Well, as a defense attorney, that's great.
That's your best day.
I like when you don't report it because it was so unless you can show that you were not able to report it, it makes it look like it was so non-consequential to you that you didn't bother. And it wasn't until after you thought about it for a while and you thought about how this may be a situation where you don't have to work again in the future because you're going to win the lottery.
Did you just say
off
that out
my
loud
client.
on my show? That the plaintiff is going to win the lottery after it all comes out now. These are the questions. Now you're getting a little bit of piece of what goes on at home between plaintiff's attorney and defense attorney. So the defense perspective is,
please don't report it.
Please don't report it.
But if you do, that's dangerous for the defense because typically some untrained person goes out and writes up a report and says, oh, there's all this ice on the ground and the person slipped and fell because of ice. And now
so here's my moment. Report it.
Definitely
Please report it and hope that there is a staff member there who can come out and take a look at it. The other piece of it is it gives your client, Jeff, an opportunity to inspect it too and see what's going on. See if there really was a condition there or take their own pictures. But there's some kind of investigation that happens because the other piece from the plaintiff's perspective is, even if you don't wait 3 years, what if you do it, report it the next day, report it a couple days later after you've been to the doctor, whatever it is, go back and get it reported because there's nothing worse than finding someone who really did legitimately fall, who is legitimately injured. First step may be to try to contact an insurance adjuster and discuss the claim. And the response you get on the other side of the phone is, I don't know what you're talking about. This person never reported it, and nobody ever looked at it. As far as we're concerned, this condition didn't exist at all. So get in there and report it, and get to your doctor. A lot of times, because we're in upstate New York, we try to be tough. So everybody goes home and says, well, I'll be fine in a couple of days. No big deal. If you've really fallen and you are that injured and you are concerned about it, get to a doctor, get it memorialized, get it into the medical records. Don't embellish, but also be honest. Don't walk in and say you're fine. You're there for a reason. So the doctors come in and say, how are you? And you say, oh, I'm okay. I'm pretty good. Explain what's really going on and what's happened. And then after that, the attorneys can get the weather reports that we talked about to determine, was there a storm in progress? Was there not? What was the temperature? Was there any precipitation of any kind? Attorneys can get these maintenance logs that we've talked about. Were there reasonable inspections? We can ask for incident reports. We can have a fight about incident reports here and there.
Well, and there's video. Frequently,
and surveillance video.
There is video of parking lots, things that happen at grocery stores or shopping malls or gas stations or convenience stores. And if you get in there soon enough before the defendant's destruction rules come into place, it's a way to preserve all of that data.
And when you talk about destruction rules, what we're talking about is that surveillance video, oftentimes not through truly destruction, but just through the basic operation of business. Those tapes get taped over, whether it's in a 24-hour cycle or in a 2-day cycle or a week or 72 hours or whatever it is. There is some cycle to that, which is why it's important to report it. Because once you report it and that property owner, that defendant knows that there's a potential case, they have a duty now to preserve that information and that evidence, or they can be in some big trouble down the road too. So those surveillance videos come into place. Also measurements, when we start to talk about those defects. Was it the pothole that filled in? Was it the snow pile that was over the grate? Was it the gutter that continued to leak? To get out there, to take measurements, to look at the defects, to get pictures, to try to get on the property over time to look at it. Those are all important pieces. And we had a funny story during the break, which is how social media grabs people. So tell your story.
Well, I have a slip and fall case involving a convenience store in Buffalo, New York, and the plaintiff slipped and fell, and they were nice enough to take a video of the scene, what they say was immediately after they fell, and it was snowing as hard as I've ever seen it snow in Buffalo, New York.
And guess what that is, folks?
That's saying a lot.
That's a storm in progress.
That is your storm in progress, and as a result of that, that case is probably going to resolve in favor of the defendant. But to your point about the video, that is powerful evidence to encourage the defendant to
resolve the claim.
Such that you don't, if you're the plaintiff in that situation, you don't want to have to go to trial. You want your fair recompense for your injury. And frequently, if you have that video and you show that to the insurance adjuster, they're going to make a reasonable offer to try to resolve your injuries in a way that helps everybody.
So, can you let us in on some secrets? There's an insurance adjuster. Tell me the factors that make an insurance adjuster say, we better try to resolve this slip and fall on ice in upstate New York.
Just quickly, obviously, video is very important. The lack of any type of protocols for inspection is something that they're not going to want to see. And the fact that if it was reported right away and you didn't do anything about it, or that there were previous accidents that you knew about and you didn't do anything about it, at that point in time, every adjuster is going to try to settle that case within policy limits.
So all the important reasons to memorialize things, get pictures, get those reports in, get to your doctor, make sure that you have all of the facts lined up for you if you are the plaintiff, and if you are the property owner, make sure that those facts are in your favor. Get your maintenance policies and procedures in place. Get your folks to follow them every 2 hours.
Is there a must-have documentation level for plaintiffs?
No, I don't think there's a must-have documentation, but again, in terms of the things that we've been talking about today, I want a client who can clearly describe what they fell on, what they saw, what those conditions were. To the extent there's a family member who may be able to tell me a little bit about it, I want to see that too. And obviously, it's got to be a significant injury, because any injury to prosecute it is going to cost money, and that money is going to come out of any type of resolution. So you want to make sure that the injury justifies going through the time, expense, emotional toll of a claim, and it also, frankly, gets an insurance adjuster's attention to try to resolve it.
The best thing, though, of course, is to try not to fall down in the first place. And
get some cocoa, get some big boots, and some winter gloves.
And stay off the phone.
Keep your eyes out. Put the phone
off
down.
The phone.
Well, this has been fun, Jeff. It's been take your spouse to work day, kind of.
Well, thank you for having me. Hopefully
Thank you
you'll
for
have
being
me again.
here. We'll think of our next TED Talk to bring you through on. But for those listening, my other half, my better half today with me, Jeff DePalma, thank you very much. Bob, thanks for having us.
Absolutely. Thanks for coming out, both of you, and give them some information on your practice in case they have some more questions about cases where folks gravity is not their friend.
So if you are a plaintiff and you have been injured, it's the law offices of Jordan DePalma, and I can be reached by calling 585-673-3053. And if you are a property owner or a potential defendant and your insurance company lets you pick your attorneys, the attorneys at Osborne, Reed & Burke can be your best friends. And Jeff DePalma can take that call at 585-263-9565.
All right. Thank you both so much. We'll see you next time on Off the Record.